So, Renato, is Leticia James actually in danger of being convicted of a felony?
It's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rengappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm the author of the Substack, The Freedom Academy.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet. Well, Asha, I mean, we have it's like another week, another highly questionable, weaponized indictment to discuss, and this one against Leticia James, who, of course, led the office that brought us a very significant civil matter against the Trump organization.
Yes, ironically for defrauding banks and insurance companies, right? And in particular for inflating the value or deflating the value, I guess, depending on who he was communicating with in order to obtain potentially favorable loan terms or lower premiums, et cetera, which resulted in a pretty both a finding of liability and then a hefty penalty, which was tossed out by the New York appellate courts.
Right. Now, of course, that was a civil case, but it was a case involving many tens of millions, I believe, in alleged fraud. Here we have a criminal indictment involving a supposed savings of $18,933 over the course of a loan. And I guess, obviously Leticia James responded, of course, with the video. She talked, she used the term weaponization. She talked about how that's, what Trump is doing here. And I think, that is a more, in some ways, an issue that a term that, is being conflated. Obviously, you and I spent a while last year talking about the weaponization committee that the Republicans put together in the House. But I think one thing that isn't questioned, in my opinion, is you can look at statistically, is when you look at this dollar amount that I mentioned. I think it's very important. $18,933. Typically speaking, Asha, U.S. Attorney's Office have what's called prosecution guidelines, and they don't handle cases under a certain dollar amount. I know in my former office, it was very, very difficult to bring a case that was under $250,000, under $500,000, under $1 million worth of fraud, particularly that was not against the government. And here we have a case, a 5-figure fraud case that is below the amount a lot of local prosecutors might bring, and yet it has the full weight of the United States Department of Justice behind it.
Yeah. So on the weaponization piece, this is, I guess, orthogonal to what we're going to be talking about. So we don't need to go down this rabbit hole. But I do think that if you look at the scholarship on authoritarianism and fascism, that one of the things that these movements and people, would-be authoritarians, do is they basically render language meaningless. I mean, there's a whole 1984 like double speak and, double think and all that. But this is a little bit different, which is just to basically make these terms devoid of any meaning. So yeah, so now we say weaponization and everybody thinks, in other words, people don't pay attention to the words anymore because they've been distorted and misused. But I agree with you that this is an actual weaponization. And I think it's worth unpacking what is in this indictment, because this is not the indictment that was teased, if you will, when Bill Pulte, who was the political appointee that had access to all of these loan documents, I think we talked about this a few weeks ago, was looking at mortgage documents and people listing first, two homes as their primary residence, et cetera. And it looked like that was the direction that the Trump administration might go in with regard to a property that Leticia James purchased in 2024 in Norfolk, and whether she listed it appropriately or classified it appropriately or something. This is a property in Norfolk, Virginia, but it's a different property. It was one that was purchased in 2020. and it isn't so much about whether she listed it improperly as a, I mean, it is how she listed it, but it wasn't about her primary property and then a secondary property. It is about the purpose for which she was going to be using this property. That is the claim here, that she misrepresented that.
That's right. And it's worth noting that that original issue that we talked about, that was essentially debunked once it became apparent that she actually was co-signing on a loan for her niece, who was going to be using that as her primary residence, and in fact did so.
Right.
And so, and there was, I believe there was also separate documents to the bank disclosing that Ms. James had filled out. And so this is really about a property in which Leticia James qualified for a better rate because she signed a document that indicated that this was going to be like a secondary residence of sorts. And so, under that, requirement, they're essentially saying, well, the indictment, the way the indictment reads is Leticia James rented this out to someone else. And so therefore she made a false statement when she said that this was going to be a secondary residence. That's essentially what the indictment says. That's not entirely the entire picture of it, but that's what the indictment says, the four corners.
Right, because what the indictment is alleging is that if she planned to rent it, then it should have been considered a rental investment property, in which case she would have had to have gotten an investment mortgage as opposed to a second home mortgage, which, as you point out, would have been slightly higher interest rate. She got a 3% interest rate on her the loan that she got. She avoided, according to the indictment, a 0.815 higher interest rate. And that's how they get to that amount that you cited earlier, that basically the difference in that interest rate results in approximately $17,837 in savings over the life of the loan, by the way. I'm guessing, I mean, it doesn't say, but I'm guessing that it's a standard 30-year mortgage, which comes out to about a savings of somewhere in the ballpark of $50 a month.
Right. Now, I want to, before we get into anything, into the weeds on any of the facts here for a second, just looking at the four corners of the indictment, a couple of things I want to make sure that our listeners, viewers understand. Merely making a false statement on a document that you're submitting to a bank does not mean you've committed a felony. And that's, I think, an extremely important point. Obviously, it's very important to be accurate in the documents that you submit to banks, particularly ones that they rely on, and we should all be accurate in those. But a mere inaccuracy in those documents does not mean you've committed, let's say, bank fraud, which is the lead charge here. In order to commit bank fraud, you have to do that, submit that statement, false statement, knowingly. That's the first thing. You need to know that it's false and have your mind on that fact. But then secondly, you need to do it with the intent to defraud. And so the idea here, and what the government has to prove, even if every word they say in the indictment is true, and there's no other facts that are relevant, they have to prove that her intent in filling out this loan doc was to defraud the bank. Like, it was all about getting, their important purpose in her mind, or
of saving that $50 a month.
Yeah, saving $50 a month. Okay, so just on its face, it's like that. I just want to make sure everyone understands that, right? And even now, and there's also an issue of whether it's material. In other words, how much it mattered to the bank, whether something capable of influencing the bank. There's another charge that they have here, which is a false statement to a financial institution charge. Also a felony, something that I charged and tried as well, along with bank fraud when I was a prosecutor. It does not have a materiality requirement. That's like a big difference between the two. But you actually, it's a little bit different test. There, the question is, did you make that false statement with the intent to influence the bank? Were you trying to influence the bank in some way? And that is really what this case comes down to. And I'll just say, Asha, like, if you had, let's say, ChatGPT or whatever, an AI, a robot, your Lieutenant Commander Data as your jury for this kind of a case, looking at the circumstances, I think it would be very difficult to meet any of those elements, even if everything the government said here was true and there was no other facts that were relevant, because it's hard to see that this would be someone's intent in filling this out. So I think on its face, this seems to be a somewhat questionable indictment, even taking without looking any further than that.
Well, I would argue that it would be material if it made a difference in the kind of mortgage that she got. Right.
Correct. That's right. I agree with that.
I think that that's where it is material. But I think the bigger issue that I saw in this is that I'm not sure that what she did was even a crime. And I'll tell you why. So the indictment alleges that she obtained her second home mortgage, which had a rider. It had a second home rider. And the rider said that she was prohibited from using the property as a time-sharing or other shared ownership arrangement or agreement that required her to either rent the property or give any other person control over the occupants or use of the property. That is the rider. This was a mortgage that was backed by Fannie Mae. The indictment then alleges that she received, it doesn't say when, but that she received at some point rental income based on her Schedule E tax forms. And it's not clear how much she got, but there was a great piece in Lawfare that sort of cross-referenced this with her financial disclosures to the state of New York, which showed that in the year 2020, she received somewhere between $1,000 and $5,000 in rental income. But here's the deal. I don't think, based on what I have read and the background that I have seen, that that second home rider actually prohibited her from renting it out herself for a short period of time.
That's right. For at least the first, in at least the first year.
And at least the first year.
That's right. And so that's what I was trying to bracket that. I don't think you and I disagree on that. I was trying to bracket that because I guess my view is like, that is almost like a factual question. And maybe that she's actually innocent. But I actually think on its face, like, I don't even know if this is the sort of indictment that you would bring, even if there was no factual issue at all. I
don't even think it's a factual issue. I think it's a legal issue, Renato. And that's what I was going to suggest, is that maybe she could get this dismissed on a legal basis. Because if they are saying that she engaged in conduct that was prohibited by this second home rider, and because she engaged in that behavior and she told the bank that that's not what she was going to do, that that's the basis of this false statement and her getting these favorable loan terms, if that legal claim that she was prohibited from doing what she did is in fact untrue, if she was allowed to do it, then she actually didn't, there's nothing there. I don't know. I think that's a legal matter on what this rider prohibited. And what's really interesting is that there is this Wall Street Journal article from April 18th, 2019. The title is Second Home Rider Rewrite. And it basically is in the Wall Street Journal and explains how Fannie Mae updated its second home rider explanation to basically explicitly allow homeowners to rent a second home after 1 year of ownership and allow short-term renting in the first year. And the reason that they did this clarification was because at the time there were a lot of people getting these second home mortgages that had these riders, and they wanted to know whether, when they weren't using the property because it's a second home, whether they could put it on Airbnb or rent it out in some way. And basically what Fannie Mae said is, yes, in the first year, as long as you do it for a short term, it's fine. After that, there's no bar at all to you doing that. Basically what they were trying to prohibit is basically buying a property, handing it over to a management company. So you buy like 10 properties and they're all being run by management companies that are controlling who is in the home. And, but you're just using it purely for rental income. And that is what Fannie Mae said that it considered a rental investment property. This property had 3 people living in it, one of whom was her great niece, I believe, and her great niece's family. And at least according to the reporting, Leticia James went and stayed there regularly herself.
Yes. I think that here's the thing, though. I think here's some part of which I think we have a difference of opinion.
Okay.
I think a lot of this, unfortunately, will not be able to be handled via a motion to dismiss. And I think it kind of comes to a fundamental problem or issue that we have with our criminal justice system, federal criminal justice system. On a motion to dismiss, the judge has to assume that the allegations, the indictment are true, A.
I see.
And,
Yeah, you're
B,
right.
cannot bring extrinsic evidence in.
Yeah, you're right.
And so accordingly, that's a real problem. And I will say this is somebody who's been on both sides of it. It worked to my advantage as a prosecutor, and now that I'm on the defense side, and that's where Leticia James is going to be, it can be a real problem because you'll have a very highly questionable case. If you can't convince the prosecutor to change their mind, I'll put it all out anyways in front of the judge. I'll make motions and I'll throw all this evidence out there and show the judge like this is a problematic case. Try to get the judge to make some comment to the prosecutor about it. But at the end of the day, if they want to go to trial, my justice for my client, and if I was representing Leticia James, if I was Abby Lullaby in the same spot, I have to go to trial and put it all out in front of the jury. And that's why I mentioned a moment ago. I mean, I think if we had a robot judging this, it would be a pretty easy case. And the question is going to be, will 12 random people in the Eastern District of Virginia be as fair as Lieutenant Commander Data or ChatGPT or whatever?
Well, and you saying all of this makes me realize that it creates some perverse incentives, right? Mm-hmm. Because if the motion to dismiss will always be based on whether the facts as alleged by the government are true, then a poorly drafted, charge that sort of glosses over and kind of is misleading or even misrepresenting certain facts are then taken as true for purposes of the motion to dismiss.
Correct. It really gets to, and this is something I've mentioned in a prior episode that I've talked about is, how much our criminal justice system has baked into it prosecutorial discretion and this concept that prosecutors have to be exercising that discretion in an appropriate way. In other words,
the presumption of regularity, we've talked about this.
Yeah, that's right. That's been your term for it. And I think that the way I look at it is, there's a very famous speech that Justice Jackson gave. Yeah, former Attorney General as well and former Nuremberg prosecutor gave about federal prosecutors and how they have to act in a certain way of, like, gentleman was the term he used, but it was to have a certain element of fairness. And I think a lot of prosecutors, and myself included, took that very seriously. But if you're somebody in this case who's acting in bad faith, our system really doesn't offer you anything other than a lot of robust rights around a trial. That is supposed to be your protection. And the problem is, for someone like Leticia James, she has to suffer a lot to get there. Not only millions of dollars potentially in legal expenses, but also years, potentially of criminal litigation to get there.
So speaking of bad faith, it was reported that there was evidence presented to a different grand jury regarding this matter. Or no, maybe not evidence presented to a grand jury, but there was testimony in front of a grand jury where, and I'm sorry, I'm blanking on it. I believe one of the people that was residing in this home that testified that they lived there. This is where we get this information that Leticia James was visiting regularly and that they didn't pay rent and weren't expected to pay rent. Now, that was not the grand jury in which the indictment was ultimately sought. And so that is exculpatory. That is exculpatory to Leticia James. So what are the ethics of they went to a grand jury. I believe that one was in Norfolk or in Virginia. I think it was in Norfolk, Virginia. They're like, oops, the grand jury just heard something that, might make them no bill this. So they abandon that and then go to the Eastern District of Virginia and then present testimony, evidence, but conveniently omit the exculpatory testimony. Is that prohibited? Because that seems super sketch to me. Like, then what would stop a prosecutor from just going around shopping an indictment across a number of different grand juries?
Yeah, it's a great question. I mean, look, one thing, obviously, there's a venue issue, right? So it's got to be in wherever there's venue for the crime. But yeah, look, if it's really exculpatory, then they have to disclose it, first of all. All right, that's the first thing. There can also be an argument that there was evidence, that should have been presented, or that they presented misleading evidence or testimony to the second grand jury. And in front of a grand jury, you don't have the rules of evidence that apply, A. And B, of course, there's really no requirement that the prosecutors present a complete story. So it's an odd situation. So typically, although defense counsel try to raise issues regarding grand jury testimony, it's often something that does not result in a reversal of a conviction. But I think it's one of many potential avenues in which she may want to have motion practice here. Of course, she also has an argument about selective prosecution and other things. In some ways better than Comey, because Comey had a very unique fact pattern that she doesn't have, right? This is a fairly common fact pattern. But I think that, part of it, Asha, there's got to be a weighing of one side versus the other. The more motions that she files, the more process that she avails herself from, the longer this drags on and the longer the burden is on her and her family. I think she should exercise those options, but I just want to make sure our listeners and viewers understand that comes as a cost as well.
Yes. And I mean, to the extent the government doesn't have to hand over the exculpatory information until after in other words, that doesn't kick in until the process is already underway.
That's right. Now, and to even put a finer point on it, the discovery obligations that the government has often, don't kick in until, fairly advanced in the process. In other words, grand jury transcripts are often not turned over until a couple weeks before trial, that sort of thing. And other types of, there's some types of information, like, for example, FBI reports, FBI 302s. Technically speaking, those are what's called Jenks materials. There's a particular statute that covers those. Technically speaking, they don't need to be turned over until the trial's already begun. Now, typically speaking, people do turn them over before that. I used to turn them over on all with the initial batch of discovery, but I as somebody who's practiced across the country, I will tell you there are offices in this, U.S. attorney's offices that will turn that stuff over days before trial, sometimes in the middle of trial. And so accordingly, that really can put James in a situation where she has to bear a lot of costs and burden on herself and her family, and obviously put herself into a situation that's very fearful, something that I think people would be very afraid of, their own federal criminal trial, in order to avail herself of her rights, and in a situation that's highly questionable and highly suspect.
Yeah. I also want to just note that, like the Comey indictment, this was only signed by Lindsay Halligan, which I assume that's unusual.
Yeah, that is unusual. It obviously varies district to district, but my understanding is in that district, AUSAs would be signing this. There also was no other prosecutor on the case. at the time of indictment. And then they brought in prosecutors from another U.S. attorney's office, which was quite telling and interesting as well. I think that, another thing that I will just point out, I mean, is that what a shift in norms is this like. So part of what's going on is that Trump is saying, look, Leticia James campaigned on going after me and went after me. And so really, we're doing the same thing. And I think there's always been a difference between a state's attorney generals bringing civil actions, and they're political figures who campaign. They're prosecutors you could think of in a certain sense, but they're civil. They're bringing civil lawsuits, and they do campaign, and they do make campaign promises, and they do have certain pledges and so forth. Presidents and their attorney generals are in the federal system are very different things, right? An attorney general is a appointee of the president, and we have a long-standing understanding and policy in this country of the president not using criminal prosecutions against their political enemies. And I think it's important that that the distinction between those two things are understood and highlighted.
Yeah, I think that's a good point. I will say that I do think that was a unforced error on Leticia James' part. It doesn't do anything to bolster people's faith in the legitimacy of justice when you declare in advance that you are going to, get somebody. And I think that's just a take-home lesson. Like, it does make it look like you're targeting them, even though, of course, in her civil case, there was ample evidence. And I think at that point, part of what had been happening is the previous New York Attorney General had already sued the Trump Foundation. This is do you remember the whole Trump Foundation thing that got dissolved because they were defrauding, or at least misappropriating and misusing the charitable funds. And then I believe that by the time Leticia James was running, that Michael Cohen had testified, and this was kind of out there that they were, the misrepresentation of valuation was being looked into. So it wasn't coming out of the blue. It wasn't just like, I hate this guy and I'm going to go after him. But still, I just think that it might be a good practice moving forward for people to just not run on a campaign of trying to put other people, like specific people, in jail.
Right. Now, in her case, I think she wasn't putting him in jail.
Yes, or suing them. Though it wasn't really clear at that time. I mean, I don't know that she was being specifically saying, I'm only going to go after him in a civil court,
That's right. I mean, sure, her criminal authority was limited, but I hear what you're saying there. I mean, I think I'll just draw one distinction. I mean, I do think it's totally appropriate for a state attorney general to run on the platform of, for example, taking action against the president and his administration if they're violating the constitutional rights of residents, right? And I think that's an important distinction. I mean, I have no problem with it. And I imagine every Democratic attorney general in this country is running on a platform if they have any sense at all.
But those are policies.
Exactly.
Those are challenging policies. Those are not like targeting people as the defendant.
I just want to make that clear. I myself ran for attorney general at one point, and I ran on a platform in many ways of taking action against the first Trump administration and trying to protect the residents of Illinois against that. And I think if that's what she was focused on, that would be one thing. But I think making comments about investigating a particular business or family is just not appropriate to make in the campaign trail. So I agree with you on that, but I think it's an important distinction.
Agreed.
So I will just say, Asha, before we turn to another topic, I think that what we're hearing, right, is that more is to come, that there are more enemies that Trump is trying to go after. He had a Truth Social post in which he posted a graphic of various different people who he disliked, who were somehow at odds with him. And Comey was the first one I think was checked off, and others were on there. And it was ironically, by the way, my favorite face in there was Rod Rosenstein, who was, which I thought was hilarious because, of course, he did a lot to further Barr and the deception around the Mueller report, and here he is
100%.
on the target list. But in any event, it
He
looks like
helped land the plane,
yes,
remember?
indeed, I do remember that very well. But nonetheless, nonetheless, we're going to see all that. And what I will just say is, one thing that I said before the Trump administration started, the second one, I said I was sort of like a good news thing or a positive view of things is the criminal justice system has really robust protections and he's not going to be able to do what he wants to do to these people. I still believe that. I think Leticia James has got a lot of bullets in her gun here on the defense side to stave this off. But I think proverbially speaking, yes, to stave off this indictment. But nonetheless, he has already won in a certain regard.
Yeah.
She's been indicted. She's going to have a substantial cost. She's got this clout. She's going to have to focus on her legal defense instead of, trying to protect the rights of the people in New York. And that is really something that we should be mourning. The fact that he can do this and will be doing this to many other people going forward. And I think how deep the list is and how broad this list ends up being really is going to determine, I would say, how much, how free our country is going forward. If everyone who starts speaking out and becoming a prominent opponent of Trump faces one of these, I think we're going to be a lot less free.
Yeah, and to your point, I just want to highlight also that I think for Trump, it's the accusation and the formal indictment is really, as you said, I think that's what he wants. He's always wanted people to be under the cloud of suspicion, and even with President Zelensky in Ukraine, he wanted him to announce an investigation into the Bidens. I'm sure that the conviction and seeing them in a jumpsuit would be icing on the cake. But in many ways, he's achieved the political goal once they're indicted.
That's right. And here, I mean, it is very substantial. I mean, the stress that this puts on someone and their family is significant. And so, Leticia James has to go to court, and she's hired a very celebrated defense counsel. She's going to have to spend many, many hours working with him and dealing with this case rather than her job, which is obviously a very important job, being the attorney general of one of our most populous states. So I think that Trump has achieved a victory, even if the case itself ends up in a defeat. And that is something we should all be concerned about. So, Asha, we've got, I think, something also very concerning to discuss as well.
Mm-hmm.
And it's a subject that that you have alluded to and you've talked about at times in the past, but it's an executive order and sort of some of the consequences of that really should be receiving more attention than it really is receiving right now.
Yeah. So it's technically a national security presidential memorandum. NSPM. And I'm just saying that because that's what it's being referred to as NSPM 7, which I'm not sure what the 7 is. Maybe it's the 7th one that he's issued of these memoranda. It's a really weird memorandum. So it's entitled Countering Domestic Terrorism and Organized Political Violence. And it opens with description of, the terrorism and political violence in the United States. So it goes through the assassination of Charlie Kirk and the healthcare executive who was assassinated. He calls it an assassination attempt against Supreme Court Justice Brett Kavanaugh. I'm not sure that was actually an assassination attempt, but it was, it might have been. And then his own assassination attempts. And then the quote unquote riots in Los Angeles and Portland, the protesters. Interestingly, he does not mention January 6th anywhere in here. But what he purports to do is to allow the Attorney General to investigate domestic terror organizations and to even designate certain groups as domestic terrorist organizations. And he's just putting under the umbrella of terrorism this whole, anti-fascist ideology, which includes, by the way, and I'm reading from this, common threads animating this violent conduct. He calls anti-fascism a violent conduct, include anti-Americanism, anti-capitalism, anti-Christianity, support for the overthrow of the United States government, extremism on migration, race, and gender, and hostility towards those who hold traditional American views on family, religion, and morality. So this is very much conflating a bunch of things, which is, belief in certain things that this administration does not like, domestic terrorism, and also just ordinary criminal activity. And so, for example, the Attorney General can investigate as terrorism things like organized doxing campaigns, swatting, rioting, looting, trespass, assault, destruction of property, threats of violence, and civil disorder. All of this is coming under this whole umbrella of terrorism. And what I want to unpack right now is he really has no authority to do this. And it's not a thing.
Yes. Now, before we get to that, because I do think it's really important, and you're going to, I assume, unpack the difference between foreign terrorism and our law versus domestic. One of the other things I thought was really surprising here. I mean, by the way, the list you said was surprising and bizarre in and of itself, right? Conflating being anti-Christian, putting that in the same category as trying to overthrow the United States government, right? Two very different things. But one thing that he also cites in this memorandum is that there's been an over 1,000% increase in attacks on ICE officers since January 21, 2025. Well, that's because ICE has been doing some really radical things in our country under this president's second administration, and so it's not surprising that people are acting in response to that. And what I will say, one concern I have is this being used, some of this being used to justify prosecutions of people who are protesting ICE activity.
So I think there's kind of good news and bad news, I guess. So, okay, let's start at the beginning. Because I think people are like, oh my God, he's declaring domestic terror. He's declaring people and organizations as domestic terrorists, domestic terror organizations. And I think the reason that people believe that that could be a thing is because people have heard of foreign terrorist organizations. Foreign terrorist organizations, or FTOs, are in fact a thing. They are a thing that is laid out in the Immigration and Nationality Act in Section 219. And this part of the Immigration and Nationality Act delegates to the executive branch, again, we're back to congressional delegation here, the ability to designate certain groups as foreign terrorist organizations. And there are certain criteria that, the findings, et cetera, that the government meets. It can declare an organization as an FTO. Importantly, we can come back to this, the designated entity has the explicit right to appeal the designation in court. In other words, you've been designated as a terrorist organization. You can go to court and challenge it. Now, it's an uphill battle because courts aren't really going to second guess it, but it is there because, these organizations technically have First Amendment rights, right? And so there is this judicial check to sort of make sure that that's not being done arbitrarily. The reason the FTO designation is important is because once that designation is made, it triggers other types of civil and criminal liability, not just for the FTO, but for other people who might be aiding it, abetting it, giving money to it. All of these things can bring you under the umbrella of certain types of terrorism statutes, like providing material support to terrorism. An FTO designation can also subject you to national security surveillance because an FTO is considered a foreign power for purposes of the Foreign Intelligence Surveillance Act, the FISA statute. So all of these things are there, but just the main takeaway here is that that is a statutory scheme that Congress has designed. There is nothing like that for domestic terrorist organizations. The United States Code has a definition of domestic terrorism, but it doesn't even have a crime of domestic terrorism. In other words, if somebody goes and bombs everything, bombs a bunch of federal buildings, that is not, and it's a domestic organization. It's a Timothy McVeigh. They can be obviously prosecuted for lots of different, criminal violations, but there is no crime of domestic terrorism. And so there is, not surprisingly, also, therefore, no statutory scheme to designate a group as a domestic terrorist organization. And this part is important, Renato. When Congress passed the provision of the INA that allowed for this FTO designation, they very deliberately decided not to include anything for a domestic organization because of the obvious, pitfalls and slippery slopes that could entail. And also because I think there's an understanding that the president kind of has a broader and more expansive authority in the field of foreign affairs than when it's turned inwards. And so I think all of these things kind of point to he's basically pulling this out of his butt.
Yeah, well, it's got an important rhetorical point for him, right? Which is he needs to justify and wants to justify using the criminal justice system against people who try to oppose him, people who are protesting, for example, his actions against ICE. And the reason I mention that, there's important, of course, First Amendment implications here. And we saw today an announcement by the Attorney General saying that Facebook has pulled off and suppressed very large, by the way, Asha,
it's like 80,000.
Yeah, 80,000 plus Facebook group in the Chicago area focused on reporting sightings of ICE, so that this way people who were concerned about being harassed by ICE or having their rights violated by ICE could steer clear of that. That's a First Amendment protected speech. You would think that there'd be a very substantial First Amendment claim there. But of course, who wants to stand up and say, okay, I am going to be the one challenging the administration's, non-content neutral, content specific speech restriction. And I think here there's a real concern, of course, about prosecution of people based on their personal beliefs as well.
Yeah, and remember when the shoe was on the other foot and the Biden administration was asking Facebook to take down COVID misinformation, it was accused of jawboning, which is something that we talked about a few weeks ago, of coercing, of censoring by putting undue pressure. And as you said, it's now apparently fair game. I also think it's very interesting that he's purporting to designate these DTOs, which are not a thing. I want to keep saying that. When, as I mentioned, the foreign terrorist organizations actually have all of these statutory rights to appeal, et cetera. So just to be clear, what Trump is basically saying, because there's nothing in his memorandum about this, about being able to appeal the designation, how the designation is going to take place, is that essentially, ISIS gets more due process than American citizens under Trump's whole scheme. But I think the big takeaway here is that precisely because it's not a thing, practically speaking, it doesn't change anything in terms of, it doesn't actually create, there's nothing that you can be prosecuted for now as a result of the memorandum that you couldn't have been prosecuted for before. In other words, but what it's doing is it's basically putting the eye of Sauron on you. And so there could be investigative resources that are devoted to, I don't know, like physically surveilling you or things like that, I suppose. Which brings me to the point that it's very clear that this administration, that this Department of Justice has completely tossed the Attorney General guidelines out the window. if they are moving on this, because the Attorney General guidelines very explicitly prohibit any kind of investigation that is based solely on protected First Amendment activity.
Mm-hmm. Yeah, look, I think it's fair to say, and it's really something that links together both of the issues that we've talked about today, that this is not your parents or your or whatever or your uncles
or even Hoover's.
Yeah, Hoover's Justice Department, okay, and FBI, and that's the point that we're trying to make here. And here, I think it's serving a rhetorical purpose for Trump as well. It's another way in which he gives some meat in the bones to this, him talking about terrorism and domestic terrorism and terrorism and violence on the left and Antifa and so on. But it's something that should concern all of us, because it obviously, when you have the government targeting people because of their speech, and labeling internal opponents to be terrorists and targeting them for that reason, it's something that really threatens us all.
Yeah, and I think our colleague Steve Laddick had a great piece on his Substack, which basically said the same thing that you did, that this is largely symbolic, it's largely rhetorical, but it's basically designed to get people to obey in advance. So people say, oh, I don't want to go to the No Kings protest because, Trump is calling it an Antifa protest, which means that, he's going to send the FBI there. There's going to be people there that are going to be arresting people. And, God knows what, I don't know, they might. But then, in other words, it's to chill speech, it's to get people to basically acquiesce their rights in advance, which then, of course, achieves their purpose of dampening dissent. I will say the one big potential implication of this, even though you mentioned, again, to tie this into the first half, that our criminal justice system has all of these due process protections if you're actually charged with a crime, and how, this kind of designation doesn't necessarily subject you to any more criminal liability. Like, they would still have to find a crime to charge you with and then take you through the whole process. I think the more troubling thing here, Renato, as I wrote in my Substack, actually, it's going to come out tomorrow morning. I wrote it for Cafe and it came out today, but I'll republish it in my Substack tomorrow. We're speaking on Tuesday of this week, is that they are killing terrorists without any due process using military force. And that, to me, is potentially the bigger problem than, being investigated or charged with some kind of crime because you've been labeled a terrorist. It's that you've been labeled a terrorist. There are now military deployed in the streets. And the Trump administration's position is, we can use lethal force against anyone who we designate as a terrorist. I mean, that's pretty much kind of their reasoning at this point, based on what they're doing in the Caribbean.
Yeah, it's really just underscores the seriousness of that other issue that we've talked about at length, and how what's happening to someone in the waters of, Central or South America can have an impact here at home as well. So, Asha, before we go, I will say it is starting to get cold in Chicago. It was really warm until last week. And then I came back. I was in Texas last week. I came back and wow, it was cold.
Same. It has gotten quite cold here. Not quite cold, I guess. It's colder. It was in like the 70s and 80s. So for me, it feels pretty cold. And I like the fall. It is feeling like Halloween, though, now I'm looking ahead at our Alaska cruise, and I'm kind of like, I am excited about it, but it is like, now I'm like, oh, Alaska. It's not the Caribbean.
Yeah, I hear you. Yeah, the last Oceanic cruise I did was in the Caribbean, which sounds a lot better right now. I hope that in the middle of the summer of next summer that Alaska sounds better. So let's hope on that.
It'll be in July. And whatever the temperature, we'll be getting mojitos.
Absolutely.
On the
Absolutely.
ship.
And we might need some hot cider or hot chocolate at the same time. If you're interested in joining us in that, there is a link below. You could just, take a look at that, and we're going to have kind of additional Zooms and meetings with more information.
And can I just add here, Renato, that I was just at a conference this past weekend at my alma mater, and the president of the university President Eisgruber was talking about this moment and being courageous. And there were so many people in the audience that from different backgrounds and professions and stuff that were there. Being in the same space, the same physical space with people who care about the same thing that you do, are fighting for the same thing you do, it was so energizing to me. Like,
Yeah.
I felt like it made me think of, the cruise and what we're putting together, and just that I think it makes a difference to making you feel more empowered and feeling less helpless to just be around. And you're like, I'm not crazy. Everybody else is also nodding their heads. Everybody else is asking what they can do. And we're all kind of coming together. So, I'm excited for that piece of it as well.
Same here.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.